Okay, ladies and gentlemen, thanks for staying after the first coffee break. It's always a very dangerous moment in conferences when everyone had his or her coffee and cakes and then leaves immediately. So thank you very much for your endurance and commitment to stay. We have a very distinguished panel with 4 colleagues. Unfortunately, one of the members of the panel will join us only online. He's Peter Kohl from Birmingham, UK. And we'll talk about the issues of content regulation in social media. I asked all the panelists to present their views in 20 minutes, and after which there will be an opportunity to raise questions. I don't know whether you're familiar with this with the system I was just introduced to, the Slido. But if you go to that website on your phone and type in this event code, then you will get the chance to raise questions even during the presentations, and I will hopefully see those questions on the iPad. So first, let me introduce our first panelist, Dr. Peter Kohl. Hello, Peter.
Hello. Can you all? Oh, there we go. I think I'm on screen. Can you all hear me okay?
Yeah, we can hear you, and we can even see you. That's even better. I will briefly introduce you, if you allow me that. Peter is an associate professor at the University of Birmingham. His primary research interests are the changing nature of journalism and how this impacts on free speech, press freedom and regulation, and the concepts of privacy and reputation. His other research interests are defamation law, including the protection of corporate reputation, a very interesting issue, and media power and media pluralism, the role of media within society and its impact on democracy. And he's going to look at the liability of online intermediaries in the context of defamation. In particular, he's going to focus on the concept of publication. And hopefully, if time allows that, we will also provide a brief update on the Data Protection and Digital Information Bill and the draft Online Safety Bill, which future is a little bit uncertain at the moment, but still it's important to know what's happening in the UK. So, Peter, the floor is yours. Thank you.
Thanks, András. That's a great introduction. Thank you. And first of all, apologies to everybody for not being able to be in Budapest in person. I'm really disappointed I can't be there in person. Unfortunately, we're in the middle of a very busy teaching term at Birmingham, and I'm actually giving this paper sandwiched between 2 criminal law seminars. So I'm off to teach criminal law as soon as I've given this paper. So thank you for allowing me to be here, at least virtually. András initially asked me to provide an overview of the English online intermediary liability system. But as András has alluded to, because of the recent political turmoil here in the UK, which I'm sure you're all well aware of, it's rather embarrassing. And the fact that we are now on our 3rd Prime Minister since July, 2 important aspects of that system are in a state of limbo, they being the regulation of online harms and the reform of our data protection regime. So I'll just briefly mention them now before I move on to the main focus of my paper. So following Boris Johnson's resignation in July, it was announced that the House of Commons vote on the Online Safety Bill will be delayed until the autumn, which forced at the time the Department for Digital, Culture, Media and Sport to issue a statement denying the legislation was going to be dropped entirely. Now, Liz Truss, who took over from Boris Johnson as Prime Minister at the beginning of September, said that her government would forge ahead with the bill, but would make significant amendments to it. However, when Rishi Sunak took over as Prime Minister, following Liz Truss's tumultuous 45 days in office, the bill was initially withdrawn from the House of Commons schedule. Now, it's just been reported in the media that the bill will be brought back to Parliament, but it is going to be subject to quite substantial changes, with the media saying that the controversial legal but harmful provisions will be largely scrapped, among other changes. Now, the result of all this is it's reignited concerns over the bill's viability. We've got many internet safety campaigners fearful that it may not be enacted, or certainly if it is enacted, there will be significant changes made to it. So that's where we are at the minute with the bill. It's very difficult to know what's going to happen with it, but I just wanted to mention that one briefly. Now, this political inertia that's afflicting the UK isn't just affecting the online safety bill, unfortunately. Data protection law, again, as I mentioned at the start, is also an area that's in a state of flux. So again, just in summary, in July, the government published the Data Protection and Digital Information Bill. Now, the bill, if it's ever enacted, would reform areas of data protection and electronic privacy law by amending the UK GDPR, our Data Protection Act 2018 and the Privacy and Electronic Communications Regulations 2003. However, for the same reasons I've explained in respect of the Online Safety Bill, this has also been paused. And at the time I was putting this paper together last week, its fate was still unknown, and there were still rumours that it might be shelved or again significantly amended. So again, it's a case of kind of watch this space with what will happen with our data protection regime. So, rather than trying to second guess what's going to happen with data protection law and the regulation of online harms, as András said at the beginning, I'm going to discuss an area of law relating to intermediary liability in England that is excluded from the Online Safety Bill, but has been the subject of some very interesting case law. That is defamation, and when a platform or a search engine is or isn't a publisher for the purposes of founding liability. So I just want to make some preliminary points to begin with. As we all know, the internet and social media have had a profound impact on how we receive and impart information. They have, in my view, changed beyond recognition our communication ecology. There is another dimension, however, to the way in which companies such as Google and Facebook and Twitter have changed this ecosystem that has, in my view, led to an incoherency in the law. That is our understanding, or perhaps our misunderstanding, of the roles and functions that are performed by these companies. On the one hand, the corporate messages that are communicated by the likes of Facebook and Google and Twitter is that they are not editors, they're not authors, they're not publishers, and that their role in content production and dissemination is largely passive. Yet the evidence points clearly to the opposing view. That is that the algorithms that are designed by the employees of these companies curate content and influence what users see, and that these algorithms shape how content is aggregated, presented and distributed, and how users consume material. By presenting content in a particular way, or by removing material that conflicts with the platform's business goals, or perhaps its ideology, or contravenes its own policies, these platforms are playing an editorial-like role. And we are now seeing this lack of clarity played out in the arena of defamation law in respect of the concept of publication and who is or is not a publisher. So it will come as no surprise to you that that online publication has proven to be a thorny issue, particularly in respect of platforms or companies which host third-party comments and in respect of search engines. So we'll turn now then to defamation law and this concept of publication. In the case of Godfrey and Demon Internet Limited, Mr. Justice Morland held that an intermediary which hosts content is a publisher who can therefore be liable for defamatory content published by third parties, regardless of whether it has knowledge of the content's defamatory nature. Now, for over a decade, this was the accepted position in English law, until 2013, when the Court of Appeal cast doubt on the decision in the now famous case of Tamiz and Google Incorporated, which concerned a claim relating to defamatory blog comments posted on the blogger.com platform operated by Google Inc. The court stated obiter that because Google Inc.'s position was not similar to an author, editor, or the corporate proprietor of a newspaper, it could not be a primary publisher, or it seems even a secondary publisher, before being notified of the existence of the defamatory material. In respect of the position post-publication, Mr. Justice Richards considered that it could arguably be inferred that, after notification of the presence of the material on the blog, Google Inc. had made itself responsible for the continued publication by refraining from removing it. But this inference of responsibility didn't arise until Google had a reasonable time within which to act to remove the defamatory comments, which, on the facts of this case, was found to be about 5 weeks. Now, in respect of search engines specifically, the leading English case is Metropolitan International Schools Limited and Design Technica Corp and others. Now, in this case, a provider of adult distance learning courses brought proceedings against the host of an online bulletin board for allegedly defamatory comments posted on that bulletin board. Google UK Limited and Google Inc. were also sued on the basis that they had published search results that contained allegedly defamatory snippets taken from those comments. Mr. Justice Eadie considered that the absence of human agency in this process precluded any knowing involvement by Google Inc. in the publication of snippets on its web pages. Therefore, Google Inc. could not be considered a publisher at common law of such material. In the judge's words, it had merely played the role of a facilitator, at least prior to it being notified of the defamatory content. As to the position after notification, Mr. Justice Eadie accepted the general proposition from Temes, which I've already set out. However, the judge observed that a search engine is a different kind of internet intermediary, and on the facts of the case, Google could not properly be fixed with responsibility for publication after notification on the basis of authorization, approval, or acquiescence. Now, this line of authority has been met with a mixed reception in other common law jurisdictions. For instance, in Oriental Press Group Limited and Feverwork Solutions Limited, the Hong Kong Court of Appeal reviewed case law and academic scholarship from other jurisdictions and came to a decision consistent with orthodox common law principles of publication, but in doing so, contradictory to the judgment in Temes. In the Supreme Court of Appeal of Victoria case of Google and Koltay, the claimant sought damages relating to material generated by Google Inc.'s search engine. And in considering Temes, and in particular Metropolitan International Schools, Mr. Justice Beach held that he would not follow Mr. Justice Eadie's decision in Metropolitan. He found that Mr. Justice Eadie had not considered that although search engines operate automatically when a request is typed into them, they do so in a way that is designed by those who own them and who provide their services. Furthermore, the judge was of the view that as a general principle, it could not be said that just because an entity is exercising a passive role does not mean it cannot be a publisher. As he said, this would conflict with the established common law principle of strict publication, which both Temes and Metropolitan seemed to ignore. Indeed, the effect of Temes, in England at least, and elsewhere where it has been followed, may be the abrogation of the rule in the case of internet publications. But of course, this hasn't been confirmed. Now, in contrast, other cases and jurisdictions have followed Temes and/or Metropolitan, such as the New Zealand Court of Appeal case of Murray and Wishart and the Ontario Court of Appeal case of Warmer and Fournier, which both followed Temes. The Supreme Court of New South Wales in the case of Blair and Google Incorporated also followed this English line of authority, and in particular Metropolitan, with Mr. Justice McCullum explicitly disagreeing with Justice Beach's conclusion in Koltay, in which case the judge found that at least prior to notification of a complaint, Google Inc. cannot be liable as a publisher of the results produced by its search engine. So this lack of clarity and this incoherency in international jurisprudence on the concept of publication is, I think, brilliantly animated by two very recent and high-profile decisions from the High Court of Australia, namely Fairfax Media Publications Limited and others and Vola, and the case of Google LLC and Defteros. Now, I focus on these cases because, in my view, they illustrate how our understanding, or perhaps our misunderstanding, of the roles and functions being performed by the likes of Facebook and Google and Twitter has resulted in continued legal and judicial debate on this issue, and has contributed to a general lack of coherency and clarity that permeates through the jurisprudential landscape. So let's look at Vola first of all. The first thing to say about Vola is that it is slightly different to the cases I've already mentioned. The case concerned content published by three media organisations on their respective Facebook pages relating to the incarceration in the Australian Northern Territory juvenile system of Dylan Vola. Now, Vola did not allege that any of the content posted by these media organisations to their public Facebook pages was defamatory. Rather, he claimed that third-party comments posted in response to the news articles were defamatory, and that the media outlets were, as hosts of this material, publishers of that content, and therefore liable in defamation. To the contrary, the media outlets argued that publication required intention to publish, and because they were unaware of the existence of the defamatory comments rather, they could not have had the requisite intention and were therefore not publishers of those comments. Now, in making this argument, the media outlets drew upon dicta from a range of cases, including Tamiz, which they submitted demonstrated that liability for publication was not strict. Now, in rejecting this argument, and also the position in Tamiz, the position of the majority of the High Court of Australia was that publication and defamation is a matter of strict liability. Consequently, the acts of the media outlets, by facilitating, encouraging, and thereby assisting the posting of the third-party comments, rendered them publishers of those comments, even in the absence of actual knowledge. So, okay, so far so good. Vola sits comfortably with the established strict publication rule, and is another case that seems to undermine the Court of Appeal's reasoning in Tamiz and the decision in Metropolitan. But we have a spanner thrown into the works because we then have the case of Defteros and the line of case law that applies to this particular litigation, which casts doubt on all of this. So in the Supreme Court of Victoria, in the case of Defteros and Google LLC, Justice Richards came to a conclusion that correlates closely with Justice Beech's reasoning in Collegium, which I previously mentioned, and also the points I made at the start of this paper. She determined that Google is a publisher, stating, "The Google search engine is not a passive tool. It's designed by humans who work for Google to operate in the way that it does, and in such a way that identified objectionable content can be removed by human intervention. I find that Google becomes a publisher of the search results that its search engine returns to a user who enters a search query." Now, on appeal to the High Court of Australia this year, in the case of Google LLC and Defteros, the majority of the court disagreed with Justice Richards. In a concurring judgment, Chief Justice Kohl and Justice Gleeson distinguished the High Court's earlier decision in Vola, and in doing so, the application of the strict publication rule, finding that, and I'm just quoting this from the judgment, in Vola, the defendant's acts of removal and encouragement were clearly connected to the creation of the matter in question for the purpose of it being communicated to others. Vola had the additional feature that the media companies provided the place for publication. The present case has none of these features. The provision of the search result, including the hyperlink, has no connection to the creation of the article. Its creation was in no way approved or encouraged by Google, and Google did not participate in it being placed on the publisher's website. And they go on to say that whilst it may be said that the use of a hyperlink may mean the publication gains a reader, that does not mean, or that does not make Google something other than a reference provider. And similarly, Justices Edelman and Stewart found that Google in no way participated in the vital step of publication. However, to the contrary, In dissent, Justice Keane and Justice Gordon would have found against Google. Significantly, and contrary to the reasoning given by Chief Justice Kohl and Justice Gleeson, but resonating with the judgments of Justice Richards in the court below and Justice Beach into Collegium, and the points I made at the start of this paper, Justice Gordon felt that on the facts of this case, Voller could not be distinguished. And he said this: Google published the article. To conclude otherwise is contrary to the strict publication rule recently restated by this court in Voller. Google intended to publish the article in the sense that its conduct was active and voluntary. Google intentionally participated in, lent its assistance to, was instrumental in, and contributed to the communication of the article by identifying, indexing, ranking, and hyperlinking it within the search result. And he later goes on to say that the English line of authority, and in particular the judgment in metropolitan schools, offends the strict publication rule, as was reaffirmed in Voller, and that Google cannot in any event be described as playing a passive instrumental role in the process. So the discrepancy between the decisions in Voller and Defteros and the majority and dissenting judgments in Defteros itself highlights the general lack of consensus on what constitutes publication in the online environment, not just in Australia, but also the UK and, of course, elsewhere. On the one hand, Chief Justice Kohl and Justice Gleeson felt that the media companies in Voller were publishers because they, among other things, provided a place for publication on their Facebook pages. Whereas in their view, Google in Defteros did not. To the contrary, in Defteros, Justice Gordon felt that Google's participation in the communication of the article rendered it a publisher. This discrepancy comes from a general misunderstanding in society and amongst lawyers and judges, I think, of the roles and functions being performed by platforms and search engines, and what those roles and functions mean in practice. In my view, what the media companies did in Voller and what Google did in Defteros are different methods performing the same thing. That is a publisher or editorial-like function. In other words, I think they were both publishers. So, just in conclusion, then, does this matter? Does this lack of coherence, does this lack of understanding matter? The answer, I think, is unequivocally, yes, it does matter. In my view, the lack of understanding and inconsistent application of the law relating to publication contributes to, but also belies, a more general problem. Platforms, ISPs, and search engines operate multinationally. Their services aren't confined to borders, and as a consequence, court decisions relating to how they operate can be, particularly if we look at it from a common law perspective, de facto supranational. Thus, in my view, this lack of coherency and this lack of clarity in the international jurisprudence relating to publication is troubling for free speech. It could lead to censorship creep in that platforms, ISPs and search engines, and in cases such as Voller, any company or any individual who runs a social media page that allows third-party comments may adopt an over-cautious approach to monitoring what can be huge volumes of content they receive by removing anything that may be defamatory and that would therefore possibly bring them within scope of liability. Such an approach, I think, is likely to lead to legitimate content being removed because it is incorrectly thought to be actionable or potentially actionable. More cynically, it may give the likes of Meta and Google and others, we know who they all are, an opportunity or an excuse to remove content that doesn't conform with their ideological values on the basis that it could be defamatory. So I will leave it there. I hope I'm on time. I hope I haven't run over too much. So thank you very much. Thank you.
Thank you very much, Pete, and hopefully you can join us in person next time. It's very interesting, the speech of search engine and other intermediaries. Your presentation reminded me of the case in the US, Chang Baidu, where the district court established that search engines have their freedom of speech regarding their ranking list. And if we accept this ranking list as being the opinion, constitutionally protected opinion of the search engines, which looks strange at first sight, having an opinion without saying anything. And then it's even more interesting having a generally available opinion that is the ranking list without publishing it. So it's a very interesting topic. And we even had some very important cases related to anonymous online comments in Hungary, and one of those cases even ended up at the European Court of Human Rights. So the issue is very topical and very timely, and thank you very much for presenting it. Now I want to introduce Professor Uta Kohl, sitting just next to me. She's a professor of commercial law at the University of Southampton. Her research interests are platform economy, jurisdiction in public and private international law, and freedom of expression. She will give us a talk about the US state action doctrine that has at times been used to extend constitutional obligations to private actors when acting as so-called state actors, even though these private actors fall short of what it really means to be a state actor. If I'm not mistaken, she will argue that what actually happened in these cases is that constitutional obligations were imposed on non-state actors on the basis of market failures. So it's a very timely and important topic when we are discussing the several issues raised by the activities of online platforms. So Uta, the floor is yours. Thank you.
Thank you, András, and thank you very much for inviting me yet again to Budapest to talk about the platform economy. It's always a pleasure coming back here. Now, this is very much a work in progress. So the title of my talk is Reconceptualizing US State Action Cases as Horizontal Obligations in Disguise, and what it means for platform regulation. In brief, I will actually be talking what is the basis on which we may regulate platforms. Is it because platforms assume the role of quasi-public actors, even state actors? Or is it on the basis of that they are private actors, but that the market within which they are functioning is actually a very imperfect market? And therefore, the role of the state should be to intervene in the market rather than platforms being regulated as if they were part of the state. Now, what prompted me to talk about this today is that I recently was sort of discussing this with my postgraduate students, and we were discussing fairly recent US case law where actions were brought against Google on the basis that they had illegitimately taken stuff down off YouTube, and that the argument was that they should be treated like state actors and thereby be bound by the First Amendment. Now, what happened when I sort of talked about that, I suddenly had a student at the back lifting his hand and saying, I don't get it. On what basis could you possibly argue that Google or Facebook is a state actor? Clearly not. So I scratched my head, thought God must come up with an explanation. But of course, the explanation is that in the past, the public fora, the place where people could exchange ideas, was the actual marketplace. In little villages, the marketplace. And that was not, so the argument goes, a private place, but a public place. And therefore, on the internet, we should treat these public platform, we should treat these platforms where people engage in exchanges equivalent to the traditional marketplaces. Yeah, so that was That was the argument, and I have persuaded myself that that was a good argument when I actually thought, I'm not entirely sure, certainly not in the US context, where the state action doctrine is, and I will give you the case that is the leading case on that topic, is really actually designed to prevent the state hiding behind private actors to get out of constitutional obligations. Yeah, so the state cannot delegate stuff to private actors and then say, oh, actually, this has nothing to do with me. If you applied the state action doctrine to platforms, actually, it's not about sort of disempowering the state. It actually leads to empowering the state to actually deal with the platforms. I'm not saying that states shouldn't deal with the platforms. I'm just saying it is somewhat odd to deal with platforms as if they were a state agency. Now, let's get back to basics. The argument, and I assume the talk which we heard earlier on, the Texas law, which said platforms are bound by the First Amendment, that must be broadly based on the state action doctrine. So let's go back to basics. Where does it come from? In the US, it comes from the Marsh and Alabama case. This is a case from 1945, which I lied, it's 1946. Which where you had a small town in America called Chickasaw. And Chickasaw was a little town in Alabama. And for all intents and purposes, it was just an ordinary little town. But wait for that, it wasn't. It was a company town. Everything in that town was owned by the Gulf Shipping Corporation. It owned the town in its entirety. And the court in the context, in the case, commented that the town had all the characteristics of any other American town. And then they said, the property consists of residential buildings, streets, a system of sewers, a sewage disposal plant. They were somehow obsessed with the sewers, yeah? And a business block on which business places are situated. The town and the surrounding neighborhood, which cannot be distinguished from the company's property by anyone not familiar with the property lines, are thickly settled, and according to all indications, the residents use the business block as their regular shopping center, and they have done so for many years. So they described this town as a little American town with the small proviso that it was a company town. Now, what happened in the actual case? You had Mrs. Grace Marsh. Mrs. Grace Marsh was a Jehovah's Witness, and she wanted to distribute religious leaflets on the sidewalks. The company didn't like it, and what they had done is they had done in all the shops, they had distributed, put up little notices, and the little notices read, "This is private property, and without written permission, no street or house vendor, agent, or solicitation of any kind will be permitted." It was actually quite a poorly phrased sentence, but it made very clear that actually if you wanted to distribute anything, you needed to get the prior permission. Grace, let's call her Grace, wasn't going to have anything of it, so she distributed her leaflets. She was then told, no, 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 you can't do that. You need to go away and get permission. She refused to do that. Then the local sheriff, which as it happened was paid by the company, arrested her. She was then brought before a state court, not a company court, but before a state court. And then she was convicted of criminal trespass. She had trespassed on private property and not complied with the rules. Yeah. The case ended up before the Supreme Court, and the Supreme Court had to answer the question of whether this trespass law was inconsistent with First Amendment rights. Did she have a First Amendment right to distribute her leaflets on the private property? Now, the Supreme Court in majority held in her favor. It said a company town does not have the same rights as a private property owner. So they said this wasn't ordinary private property. This was a whole town. And as the company had invited people in to use it, they had then also basically opened up the town to the exercise of constitutional guarantees. And I read the holding of this case. Had the title to Chickasaw belonged not to a private but to a municipal corporation, i.e. a state corporation, and had appellant been arrested for violating a municipal ordinance rather than a ruling by those appointed by the corporation to manage a company town, it would have been clear that the appellant's conviction must be reversed. In other words, they said this corporation provided a public space. This corporation stepped into the shoes of the state in running this town, and therefore this corporation had made itself a state actor and was responsible or was bound by the US Constitution. Now, that seems all okay, sort of. Next step, how has this case been, and we'll come back to the case, because there's more to the case than meets the eye. How's this case been interpreted later on? Well, in 1972, there was a Lloyd's Corporation antenna case where it was what was disputed was whether you had the entitlement to distribute leaflets in a shopping center. Yeah, and they tried to rely on Marsh and Alabama and said, well, it's not a town, but it's a shopping center, and it's a pretty good place to distribute leaflets. Now, the Supreme Court did it, yes, went to the Supreme Court, wouldn't have anything of it, and said, no, a shopping center is not like a town. Yeah, they distinguished the Alabama case on the basis that Marsh and Alabama involved the assumption by a private enterprise of all of the attributes of the state-created municipality and the exercise by that enterprise of semi-official municipal function. The owner of the company town was performing the full spectrum of municipal state powers and stood in the shoes of the state. So they seem to say that to fall within constitutional obligations, you need to basically run the whole place. You can't just look after shopping, you also have to look after sewers and the sidewalks and the whole works, otherwise it doesn't work. Yeah, there have been later cases that have taken a slightly different tack, and the later cases have said, well, you don't need to run all of these state functions, what potentially may be state functions. You have to show that what the private actor did was essentially a state prerogative. This was classic state action. This is normally only something the state would do. Of course, in a way, given that this would inevitably arise in the context where a private actor does it, it sort of defeats itself almost by definition, because it's clearly not always the prerogative of a state. But this has been upheld, for example, in the context of peacekeeping missions, yeah? So in basically where the state goes to, the private operator is abroad and operates a sort of peacekeeping operation, yeah? Now, so you have on the one hand state in Alabama, either you have to run a town, or you have to do something which is only done by the state. And of course that in itself raises all sorts of questions. What is only done by the state? Now, going back to state in Alabama, one of the things, of course, when I thought about this case, I thought, God, what is it? why are we having constitutional rights? Why are we having human rights, fundamental rights? Is it because the state operates a sewage system? Is that the reason why we have human rights? Is it because they have sidewalks? Is it because they provide us with public utilities? And clearly the answer to that is no. That can't possibly be the reason. So what is the answer to that? Now, I think in the political theory context, you might answer, well, we have invested the state where there's a lot of power. The state has a coercive legal system at its command, and we are being given human rights as protection against the power which we have vested in the states to guard against abuses of that power. Yeah? So the state has the monopoly of legitimate physical force, which we are okay with on the whole, but we need protection in case the state abuses those powers. Yeah? There was very little mention of the state in Alabama case about any of that, yeah? Whether the company had any of the powers that are what would justify human rights or fundamental rights in the first place. So how did the court in Alabama actually justify it? Now, when you look at the case more closely, you will find that the court justified it almost in a classic way as the horizontal application of human rights would be justified in Europe. So I'm bringing here a very European angle to the American case law. What the court talked about was it engaged in a balancing exercise. It says ownership does not always mean absolute dominion. The more an owner, for his advantage, opens up his property for use by the public in general, the more do his rights become circumscribed by the constitutional rights of others. So in other words, they said, okay, the company is a private actor. They didn't actually say that, but they could have said that, who has property rights, and those property rights are opposed to the private rights, the free speech rights, or privacy rights, or whatever other rights you may have. The court specifically said, when we balance the constitutional rights of property against those of the people to enjoy freedom of the press and freedom of religion, we must here, we remain mindful of the fact that the latter occupy a preferred position. So they specifically mentioned this idea, as would be done in Europe, that if you look at the horizontal application of human rights, you look at two private actors and you say, well, on the one hand, there's property rights, on the other hand, there might be free speech rights. How do we reconcile those rights? Yeah? Classic horizontal application of human rights, never mind the state actor doctrine. Now, what did the court actually do? What the court actually did was it addressed a market failure. Yeah, in Chickasaw, there was no possibility for Grace to actually distribute her leaflets. The court was very mindful of the fact that actually, whilst constitutional rights are directed, and certainly in the US, are directed very much against the state, and the US doesn't know this sort of concept of horizontal application, so they're directed at the state, still, the exercise and enjoyment of the rights falls within the market, and it is in this market that you have the marketplace of ideas. But if you have a failing market, a market failure where you cannot have the marketplace of ideas, perhaps there's room for court intervention, and that's exactly what the court did here. And in fact, so they said, just as all other citizens, they must make decisions which affect the welfare of community and state. To act as good citizens, they must be informed. In order to be able to be properly informed, their information must be uncensored. So in other words, they said to have access to information, you need, I'm translating here, you need a marketplace where different ideas can come up. And then, perhaps as a giveaway, there was at some point the court referred to neither a state nor a municipality can completely, and this is where the market failure is, completely bar the distribution of literature containing religious or political ideas. We have also held that an ordinance completely prohibiting the dissemination of ideas on the city streets cannot be justified on the ground that the municipality holds legal title to them. So in other words, because the town was owned by a single corporation, and this single corporation imposed a single speech standard, therefore there was no marketplace of ideas. Of course, you could say to Grace, which is actually the equivalent argument in the platform economy, is you just say, oh, just go somewhere else. You don't need to live in this town, just choose yourself a better town. In the platform economy, the equivalent argument is you don't need to be on this platform, go on another platform. And we all know, as we heard in the talk before, there are all sorts of reasons, network effects and so on, while that is not so easy. Interestingly too, in Marshall, Alabama, the court also mentioned other comparable scenarios. What they talked about was the owner of privately held bridges, ferries, turnpikes and railroads may not operate them as freely as a farmer does his farm. So they said a farm is not the same as a bridge or a railroad or a turnpike. In other words, what they looked there, what the comparison was, they looked for infrastructure. Who are the infrastructure providers? And if you are an infrastructure provider, even though you're private, you may have obligations to the users, and those obligations may be based in constitutional law. Okay, what does that all mean? It all means, first of all, that the US, at least in the Marshall and Alabama case, recognizes the horizontal application of, or horizontal effect of free speech. It doesn't know it, but it does it anyway. Yeah? What does it mean for platform regulation? What it means for platform regulation is that in the moment you go to the horizontal application of human rights, what is the role of the state actor in relation to these private actors? The role in following Marshall and Alabama, and I suppose following more generally the idea that the state has a role for regulating infrastructure provider, is that the state may intervene where there is a market failure. Of course, that raises all sorts of issues. When do you have a market failure? And, you know, these platforms would argue there isn't a market failure because you can go to a different platform. But as I said before, that is actually not a particularly strong argument, much like we wouldn't say, oh, you can move to a different town if you want to make your views known. So it has implications, re-understanding the state actor doctrine, and I'm not saying in all contexts. There are other cases where the state actor doctrine might actually be justified, but certainly in the context of content and following Marshall and Alabama, Chickasaw was not, or the Gulf Corporation was not a state actor, but the Gulf Corporation was a private actor that created an environment where you did not have a plurality of outlets. So that has implications both for the state of what they can do and how they should perceive their role. It also has implications for the type of arguments private actors can legitimately make, because it is a legitimate argument for Facebook, Google, and so on to argue, actually, we are private actors, we have a right to property, we have occupational freedom. Now, that's not an absolute right, but it certainly should be thrown into the equation, and those rights must then be balanced against the rights of the users. And I think this might be it. Thank you.
Thank you very much, Jutta. That is very, very interesting. And maybe next time you can talk about the differences and similarities of the German Drittwirkung doctrine and the American state action doctrine, which has surprising similarities, even if Americans don't know about it. So now I'd like to introduce you Dr. Andrej Skolkay from Bratislava, Slovakia. He's the Director of Research at the School of Communication and Media in Bratislava. He's the author of many, many books on media regulation and press freedom. One of the books he published was co-edited with me, so we had a long history together with Andrej. And he will give us a talk about the fundamental questions and challenges of content regulation in the media law, because we always talk about platform regulation and the problems raised by social media and other intermediary platforms, but media law in the general sense is also very important if we want to understand all the issues and we want to look for solutions in the future. He will focus in his talk on the law of Slovakia, but his analysis due to the similarities in the development of media regulation and media systems in Central Eastern Europe will be also useful in order to draw broader conclusions. So, Andrej, the floor is yours.
Thank you. The pleasure. It's a pleasure. Okay. Actually, I will maybe change my topic towards platforms and social media because I follow carefully these presentations, and I can say that I found important overlap with Uta's, for example, issues she tackled like property or business rights versus other rights, and this is also in my presentation. Then we had Peter Kohl, who was talking about who is publisher, what constitutes a publication, if you remember that, and I would take this further, who is right, and what are the facts versus fake news, because this is a really important issue. And then we have Balázs Bartóky-Gönczi, who talk about basically the news can be very much political issue. Not only news, but especially commentaries, and this is my presentation about. And finally, the first speaker spoke, actually put question, and the question was, is solution better than status quo? And this is the question I would come to the end of my presentation back, because we will see what is the issue there. So this is a very recent, it covers very recent developments. I will narrow down, as I said, my presentation, and it's very much relevant for present as well, and not only for my country, but you. And I would put some disclaimer here. I am not a pro-Russian agent here, because you might think that I am, but it's somehow related to the current situation, and these issues and topics were published and by others, so I just collected them, so that's why it's like that. So we will see, and I will jump to, okay, just a few basic ideas. We have this year, basically, many changes in the media law, as you can see. Media Services Act, which actually merged Audio-Visual Media Services Directive or regulation, and some parts of Digital Services Act, actually, but not all, because of course it was just not, as we have discussed, it has been approved just recently. It will become in a week from now valid, but still, this is a huge document, 190 pages. So it's too difficult to discuss that, but there are some issues, of course, about social media platforms regulation. Then we have Press Act, which is, I can talk about this, some interesting aspects. But mostly, and I preferably focus on the last issue, basically, which is very fresh, as you can see. It was approved by the cabinet. I mean, the government, but the cabinet, not the parliament. And we can ask, what does it mean, the Cybersecurity Act, to have common platforms or social media? But you will see that it has very much with that, and it's very controversial in my view, at least. Okay, Press Act, just very few ideas. I don't even mention all of them. Just some positive aspects like protection of sources. We have transparency, ownership, advertorials are that too detailed. It's 27 pages. There are some issues which reflect the historical traditions, and some changes which were controversial as well, but there is a place to discuss, but we don't have time for that, so I move further, as I said. And all this started after the, of course, Russian invasion to Ukraine. In Slovakia and Czech Republic as well, there was blocking of so-called alternative news. We have a lot of alternative news. I will show you an overview. And it was done differently in Czech Republic and Slovakia, but both were not, I would say, not correct according to rule of law. As I said, National Security Authority pressured web hosting companies to just basically block some portals without any explanation offered, without any possibility to defend, you know, these web portals. There were 4 of them. It was certainly not in line with European Court of Human Rights case law, you know, all these aspects. So this was very controversial. This happened in both countries. And there was not much protest because journalists don't like these portals. This is actually, and I will show you, these are, it's not journalism, it's something like gossiping. You know, it's gossiping and negative opinions, personal opinions. It's very much like gossiping, basically. You know, bad people gossiping. And we have a collection of this, actually about 150, if not more, maybe only 200 of them. You can see a list of them. And the top is those who are the worst, according to this, who evaluated, assessed these websites, also including Czech ones, for example. So this is a big issue because they have some followers, and this certainly tackled freedom of the press, of speech. So, and now we have, because there was some discussion among judges and lawyers that this was basically against law, against rule of law, this activity by the National Security Authority, which is obviously true. So they, the government has passed this update on the Cyber Security Act, which should make it legal, basically, if necessary. And there are these controversial issues that I'm going to discuss. One is how it defines what is targeting. As you can see, harmful content. And you can read it, it's very wide and open to interpretation, right, definition, because it has or may result in damage or threat to security, foreign policy, or economic interests of Slovakia and its form of hybrid threat. It should be said that the Constitution follows European Convention on Human Rights. Basically, that defines exceptions from freedom of the press, right? You know, there are, but these are slightly different, as you can see in them, right? They are not what you can find in the European Convention. There are exceptions, yes, but these are slightly different. Foreign policy is certainly not included there, right? For example. So, and how it emerged? The National Security Authority can do it. There are both some discussion and some impact in this discussion. On the proposal of relevant subjects in security and defense, basically police, and we come to the police in my presentation later on, and intelligence services and similar bodies, right? In the draft version, there was that the National Security Authority can do it on its own, as it has done in February, basically. They decide we will block, you know, some portals, whatever, because of some reasons. There was no even explanation offered, even not list which they blocked. So now it is better, so there is a progress. I mean, it's not a totalitarian country I am living, but there is a change, more progressive. It's, for example, even Supreme Administrative Court is involved, must approve that or disapprove in 15 days, right? So again, the court involved, so it's much better, of course. But still, no appeal is possible. But as I said, there are some conditions which can be unblocked. And the reasons are to be published once a year, etc. Also on the website, but also the whole list of blocked activities must be published and checked by the parliamentary committee. A maximum 9 months ban, and it can be also careful consideration, not like a very brutal way. So there are some positive aspects, but it's still not the whole story. Because I will show you 3 case studies, I could do more, and this is interesting part again, when you can find those 4 reasons I discussed earlier. I mentioned James Cooper and and others' ideas, how it is controversial. We have this Georgia-Russia war 14 years ago, basically. Okay, you can think that it's simple, right? But in the view of this criteria, the result in damage of foreign policy, for example, this is related to foreign policy, or maybe it's hybrid threat. Let us see. Georgia-Russia war. This is from 2008. How different countries, the Slovakia, Czech Republic, Hungary, Poland, interpreted who was to blame in this conflict. Basically, who started the war? In 2008 situation, how different subjects, politics, I mean, not only politicians, but also political parties, analysts, and media. And you can see already here, there is a diverse interpretation present here. For Hungary, Hungarian Socialist Party blame Russia. Fidesz, then Georgia. Poland, of course, you know, Poland's friends are always anti-Russian, so that was more clear. And Czech Republic Prime Minister said that Russia is guilty, President Czech Republic, Georgia. Slovakia, it was even more complicated, because one source I found was Georgia to be blamed. Analysts, they have either no clear message or they say Georgia is behind. There are exceptions. One says that it was Russia. And liberal media, they depends on the orientation. Basically, liberal media, they say Russia in commentaries. And in Georgia, it's more ambiguous in news when they say, okay, there is anniversary of this war, so Russia behave in bad way, something like that they say. Conservative, it's mixed, Georgia, Russia. Leftist, Georgia was to be blamed. And alternative, these are these portals, which I mentioned earlier, Georgia was behind mostly. So now you have this different interpretation. You can say, is it hybrid threat? Is it, can it cause these damages? But you see that there are different interpretations of this one event in that year, not only in one country, but in the region. And it's actually very clear, because there are answers. This is not like, now we have a situation like this. Embassy of Slovakia in France, there was anniversary in August, yes, and they mentioned that everything started when Russia attacked Georgia. So the narrative now in Slovakia is that Russia attacked Georgia in embassy. Not only this embassy, ambassador to UK, the same. Open aggression of Russia started already in 2008. Again, now the situation is that it's like that. And when you look at facts, this is military spending every 2 years. The peak is around 2008. What does it say? This Stockholm Institute collected. What does it say, basically? The Georgia was preparing for war. You can say for defense, but you can say they wanted to do something what Croatia did, if you remember Operation Storm in 1990s, when they kicked out Serbs from Slavonia, right? Something similar. And then, if it was attacked by Russia, why the spending dropped down so rapidly? You know, if you are attacked by enemy or threatened by enemy, you should continue or increase spending, right? Military, for example. Evidence by B. This is Reuters. Reuters news. And it is really, there is a document supported, funded by European Union, European Commission, which says basically Georgia started war with Russia. Of course, there are some explanations, something like Russia did something bad, etc. Especially after that, they were too much intervening into Georgian territory later, etc. But you have evidence published by Reuters, back by your EU document. It's 50 or something like the pages, which says something else. So, what can you think? I mean, this is not about opinion, just it should be based on facts. And now I think that somebody will have to decide on this issue. First, National Security Authority, then the court. I don't know how they will deal with that. When the Slovak position is official of the ministry, actually check it, the ministry this week, and they say, yes, Russia attacked Georgia in 2008. Okay. So, what can we learn from this? The facts are different than its interpretation. And the question is this one. Because it kind of impact or damage foreign policy if you spread something which is not correct, not true. It can be seen. Is it a form of hybrid threat? I don't know. But the answer is probably something like this. Only state authorities can actually, in the specific areas, can act here. They can submit proposal to the National Security Authority, which submits it further to the court, the Supreme Administrative Court. Does it matter that it is incorrect? Probably no. And what we have discussed here, some of examples, the state is arbiter, what is the true, basically. Harmful content and hybrid threats. That's a real example. I don't know what is interpretation of this conflict in your countries or in your media, but I can tell you that's very interesting to observe it. So, second example, very recent one. Gas, Russia, and blackmail. There is EU versus Disinfo, one of these special bodies that deal with disinformation funded by the European Commission, etc. They publish, and I receive via email, their analysis, etc. And I received once, a month ago actually, even more, this kind of news. It is on the internet still, but you can subscribe. And the message is, I will put you bigger. Basically, they said, Kremlin spokesman Dmitry Peskov said that problems of sanctions against a number of companies, including Germany and UK, there are no other reasons that would lead to problems pumping gas. But as you can see, the text by EU versus Disinfo says, this week the Kremlin finally showed its card and spokesperson Peskov admitted the obvious, namely that Russia's gas supplies to EU have been and will stay on hold, not because of supposed maintenance, but because gas is a tool of political blackmail in the Kremlin's tools. First, so what are problems here? Apparently, Peskov says that sanctions on the companies that may repair services, etc., that slow down or stop for a while supply of gas, right? That's the message there. And this is, there are no other reasons. Without these sanctions, the companies, Russians or Western, to cooperate with Russia, there will be no problems. That was the message. I actually again asked EU versus Disinfo on this information. I said, how do you mean that? Where do you find that he said that this is political blackmail? Where do you find political blackmail? He said actually something else. We exchanged 1 or 2 emails, and after the second email, I didn't get any response. And a month later, actually, maybe a week ago, 2 weeks ago, there was a conference in Moscow, energy conference, and Putin said, the last sentence basically says, that is, of course, if our partners are interested in this economic, basically to supply gas, it's interesting situation because Russia wants to supply gas to Europe, even if we support Ukraine, we are in conflict with them, with Russia. But still, we said, you can see, it is, again, I can give you source. So basically, even month, the gas is still supplying. And Putin said, we can move to another ways to supply gas. So Russia actually says, opposite. It's not blackmail, but it's actually saying that we are willing to, we are in war with you, basically, but still we are supplying gas to you. If you agree, basically. So somehow this interpretation, I would say, is what Russian policies are. And these are important ones. Because it's a big issue, right? Gas and oil, right? And again, you can ask, harmful content, is it merits to damage economic interests, at least, of Slovakia or maybe Hungary, a form of a hybrid threat? Why not? It could be seen like that because it says something else that is reality. And then, again, in my view, difficult to find a solution to this because it's decided by state authorities, basically, what is true and how the opinions are to be framed. The final one is a very short one. And we have also kind of department at the police in my country, which deals with this fake news, hoaxes, etc. And one of these recent contributions was controversial. They say the fake calls for peace are a hidden tool of Russian propaganda. Basically, they say all peace activists are hidden Russian propaganda tools or trolls. Right? There can be, some of them are naive, of course, right? Some of them believe in that. I doubt that all of them or majority of them are paid by Russia. But the problem again is the police say something that which police supposed to later probably investigate what is behind, you know, and suggest a kind of solution to national security authority. So so is it again? This can be a foreign policy or economic form of hybrid threat. I mean, the activity of police, not of those people necessarily. So you can see this is very interesting issues that we form our foreign policy, interpret foreign events in an unusual way, so I say it politely. And now we have authority who can decide different steps. Courts can get involved, what is true or not. Sometimes they may ignore what is the reality, what are the facts. And of course, we have officially censorship is forbidden in the Constitution, but there are those exceptions. I don't think that these exceptions fit into what is in the Constitution. And I don't know what happened because I said this has been approved by the Parliament, it is just by the Cabinet. And it is softer version because there was a much harder version, much more radical in the previous draft. I could see the both versions. So there are these dangers which all my colleagues actually discuss in one way or another one because it tackles also these private business rights versus other rights. And also it is a question whether the solution like this is better than the status quo. Thank you.
Thank you very much, Andrej. It's a very difficult and important subject, whether truth or disinformation can be regulated by the state and in what way. And when we were discussing the content of the newly established Digital Services Act a couple of days ago with my colleagues, we were thinking about these issues, whether regulation on the EU level wants to do anything with this problem or not, but it's a difficult issue. Now our last presenter is Dr. Bernát Török. He's I'm sure many of you know him, but I still need to introduce him. He's the head of the Information Society Research Institute, if that's the English term, at the University of Public Service. His research fields are freedom of speech and social media, prospects of national regulations in the online world, and algorithmic decision-making. He will talk about platforms as forums for shaping public opinion and the notion of public opinion as such. He will discuss certain aspects of constitutional law relating to the formation of public opinion, which tie the hands of potential interveners and problem solvers, which were formerly the state, solely now also the platforms themselves. So, Bernát, please take the floor.
Thank you. And what is also important maybe for today, for my introduction, that in this very complex research team in our research institute, I bring a constitutional law background. So today I will be speaking about constitutional features I see very relevant to how to regulate platforms and how to regulate public discourse on platforms, not just on platforms, but on platforms as well. I think my contribution will be related to many of the issues already on the table by your presentations. But on the other hand, I will be a little more abstract, which is very good because as I heard Andrej's presentation, he brought up very special disinformation, misinformation questions, and maybe we will discuss it in the second round. I see some of the principles in my presentation that are very tricky to bring together with your cases. So it can be very challenging and interesting. So just some words about the scope of my contribution. I think that these constitutional law considerations will be horizontal in a sense that they are related to public discourse itself, but most closely related to the issues of fake news, misinformation, disinformation, conspiracy theories, fact-checking. So all these discussions that, that are very common today, what to do with it on platforms as a new challenges. And my starting point is, and I think by now it is accepted by most of the scholars and most people, that social media platforms became essential fora for the formation of democratic public opinion and public discourse. It might not enough for being a state actor and state applying the state action doctrine, but thanks God we don't have to deal with it in Europe. It is a very tricky challenge for our American colleagues. So we can follow this line, and it is enough for a starting point that they are social media platforms by now essential fora for of democratic public opinion. It was not the case 10 years ago maybe. They provided private online networking options and private communication for users, but now at least important parts of their activity, not the whole activity, but important parts of their activity is clearly considered and handled as channels of public discourse. And my contribution is about that here in Europe, we have some very basic and very decisive constitutional features, criteria, how we conceptualize democratic public opinion, and what are the key fundamental factors in Kohl law for the regulation of the formation of this public opinion. This is clearly something that is narrower than content regulation itself. So I'm not specifically dealing in this speech with this presentation with some of the traditional limits on speech, incitement of hatred or violence, terrorist propaganda, or even that speech clearly threatening state security or propaganda of other states. That is a very special, I think those are very special issues, but otherwise these features can be very important to apply. It is well worth listing them and bearing in mind. Although DSA, the Digital Services Act, already put these questions in some frameworks, but and puts many of these questions into a constitutional law frameworks. But DSA is far not the end of the road. It is maybe the end of a legislative process, but it is more a beginning, because the application of those sometimes vague constitutional law definitions and principles will be the real questions, I think, in the years to come. So the challenge is ahead with platforms. I mentioned disinformation, misinformation, fact-checking, conspiracy theories spreading online more rapidly than ever. How to govern communication, bringing these problems up including public discourse in the social media. My point is that we either respect our existing constitutional doctrine or must come up with an alternative solution, alternative considerations, but which can be more effective maybe, but must equally fulfill democracy. And that's the challenge. And to be honest, as of today, I am a fan of the former camp. So I think now we are in a position to respect the existing constitutional doctrine, and we should put these new problems into these existing frameworks. It's a huge challenge, but it's still, I think, the challenge we need to deal with. The reason is very, very simple. We should take serious our existing doctrine because it is deeply rooted in democracy and in the abstract principles and justifications of democracy. So, and the new challenges can be and should be put in this framework. The other message, I think, if we see this list, that our new solutions to these problems and challenges sometimes can be or should be handled partly or maybe larger part outside of law. Law is very important giving the frameworks for how to handle them, but speaking about these disinformation, misinformation problems, the real solution sometimes can be found rather in our culture of discourse, or the culture of our media, and even of our politics, I would say. I would list 5 key elements, 5 features for the formation of democratic public opinion. I see those elements the most relevant in this regard. I will take them from the jurisprudence of the Hungarian Constitutional Court, but these are far not just the part of the Hungarian jurisprudence. I think these 5 key elements are very European as well. So the first one would be, very simply, the public opinion, the more robust is the better. So, which is very, very simple and clear. I think it's a commonplace, and maybe other elements on the list will be commonplace as well. But if we take them seriously, these constitutional law principles that we usually feel almost and already as commonplaces, they really can lead our thinking into new directions and new solutions. Why is it that the more robust, the better? It didn't change that in a democracy we should have a responsive state to the democratic public opinion, which includes the more aspects, the more opinions, and the more details and problems, etc., are included in the discourse. The state and politics can react the more effective and proper way. My second feature, my second point is about civic participation. The thesis is that democratic public opinion supports, moreover, urges citizens to participate in public debates. It needs participation of as many people as it is possible, and of all people who want to jump in the discourse. In this sense, and by now it is sometimes hard to say, and sometimes we need to convince others that in this sense social media is not just a threat, but it is a real democratic opportunity for many to take part in the discussion. By now we can see the challenges and we can see the risks, but first we should take this participation achievement as a good thing, with this new opportunity for participation. It is for sure that where more people are speaking, the noise is way bigger there. And to be honest, we can also see that more foolish speech can be heard. But I think it is worth listening to the traditional answer of constitutional law. If there are enough authentic, trustworthy, trust-seeking voices in the arena, then we will ultimately be better off. Maybe it sounds naivety by now, but I usually say to this that I would say yes, but I would say that we should test first this advice. So after we tested it and it tested working badly, then we can come to this question, but we should test it first, I think. So the real question now is, in this sense, is coming from outside the law. Do we have enough authentic, trustworthy, trust-seeking voices in the arena? Not only in social media, but in the traditional or legacy media and in political establishment as well. The third element is that public opinion is developing according to its own logic and rules. I think it's a very nice and well-phrasing principle of the Hungarian Constitutional Court, which means that the borderlines of the domain of public debates are defined rather by the social context of speech than by normative legal standards. We can never know what becomes relevant, important, or even true in a minute in this public discourse. And so far or before, the most important message of this principle was that there should be no state authority to decide on substantial questions in this public discourse or in the formation of public opinion. By now, I think we can add to it that there should not be one or just a few central players to decide on substantial questions. It is weird if you take this principle seriously, that a really democratic public opinion is developing according to its own logic and own rules. The fourth element, very important and sometimes provocative to many people. In the realm of democratic public opinion, those participating in the discourse, speakers and listeners, are regarded as autonomous and responsible citizens who can see and judge the main motives, context, and aspects of the discussion and the speakers. We can and we must see two things regarding this principle. The first is that reality, and it might be a strong understatement, does not completely cover this assumption. The other thing, which is important in this sense, that in the realm of other spaces, other communicative spaces or regulatory regimes, it is not the case. So if, for instance, if you see a consumer protection law, we protect consumers as people vulnerable against producers and strictly regulate commercial speech so that we avoid misleading information about our products. But it is not the anthropological background of public discourse. Like it is not the anthropological background of people casting their votes at the ballot box. We cannot legally protect people effectively from misleading motives and content and conspiracy theories. I think because we cannot have other anthropology in this when the mentioned one, which is important again, that we need authentic sources and voices in this discourse. If we have, then we are better off. If we don't have, then we can be in serious trouble, as sometimes we can see around us. And the fifth and last feature is that there are central vehicles of the formation of democratic public opinion. Before it was the press, and it is still the press and media, which had and has a special role in this formation of public opinion as driving forces and driving players of public discourse. And this special role comes with special responsibilities and regulatory intervention options, but it is first and foremost not about the content, but the structure of public discourse. For instance, the ownership restrictions in media law. Now we can add again to this landscape the social media. By now, social media is also a central vehicle of the formation of democratic public opinion, which means that there can also be special standards for that, for those media platforms, but mainly on the structure and not on the content when it comes to political public discourse. In a nutshell, I think that we should look for new solutions and new regulatory solutions, mainly affecting the navigation, the algorithmicized recommending systems, and not about the moderation itself, or at least more about navigation and less about moderation. And my closing or summary or closing remark is that if you see this list of 5 features, elements of formation of democratic public opinion, I think we can say that democratic public discourse and opinion is a very dangerous thing. Constitutional law can help create the proper frameworks and can give the chance for forming it, but it cannot protect us against one another and against us. The question of whether it is actually forming this discourse and this opinion is actually forming in the right way, meaning helping democracy and rational discussion survive, it remains outside of the legal regulation ultimately. Which is, I can say that, totally familiar in the world of free speech. Because free speech in itself, or the free speech doctrine in itself, cannot reproduce the cultural and sociological prerequisites of a healthy social debate. It can help create the frameworks for it, but the solution for this sustainable, democratic, lively political and cultural debate can be found outside of law, I think. Thank you for having me.
Thank you very much, Bernát. Now we have 27 more minutes for questions and maybe some remarks also. You still have the opportunity to use the Slido system to raise questions. We have already 3 questions submitted to our participants. And I also encourage our participants to think about questions that can be raised related to the individual presentations. So if you want to have a proper discussion of a democratic public sphere here, then the opportunity is there. So the first question goes to Uta. if you allow me to. That is the order of the questions, so it's not something that I made up. The question is, what legroom does the state have to create fair balance is in inverted commas, regarding questionable exchanges on platforms that touch upon horizontal violations?
Okay. I was actually listening to the other presentations, thinking about my claim that the state can intervene on the basis of market failure. And I think the market failure, and this relates to the specific question, operates on a number of levels. It's not just that you are stuck in a platform, but there is within a platform, I think, a market failure in terms of hearing all the voices, and that some voices are a lot louder than others, and that is the deformation of the public discourse. So I think, as far as I could see, there is room for the state to intervene to ensure a certain civility in the discourse, or to prevent bots, you know, amplifying certain views over others. And I know for certain in Germany there have been cases, my legal background is very much common law background, but I have looked at the German law, and there have been decisions where the courts have said, actually, the way platforms respond to politicians making statements online really discourages people from becoming politicians, because especially in the case of women, a lot of the responses are so abusive that I think that there is a lot of deformation of public discourse going on, where I think the state has a legitimate role to intervene, and I was broadly put that as a market failure.
Thank you. Next question goes to Andrej. And the question is, are there any concerns about the practical implementation of the Digital Services Act in Slovakia, similar to the ones presented by the Hungarian keynote speech? If you need some more time, I can raise the third question to Bernát, and then you can think about it.
Okay.
Shall we go do that? Okay. But the burden is getting more and more difficult.
No, because I don't like, don't like to answer very quickly, these kind of questions, I always need, I think people need time to think, and that's I think it's important. So, I don't know, to be honest. That's the first question, because there is no much discussion about that. There will be discussion more when it will be actually, in force, so to say. And I said more important was the other issue, the Cybersecurity Act is more controversial, because this regulation on digital services basically was partly in place already. Some aspects of it, it's very similar to what is a television regulated, radio, and it's also, so we have always this tradition of 200 or 300 pages of detailed regulations, sanctions. There are sanctions, for example, up to 100,000 euros, for different breaches. There is a listed everything there, of 4% of turnover. So there are these kind of issues which can come to the court. But as I said, the major issue is different, not this one, because this we'll see how it will work. And we discuss more, as I said, also we discuss more Press Act. We had this thunderstorm of regulation in media field. So this was not the major field of discussion currently in my country for these reasons, exactly. Of course, we had also many political scandals, crises. So there was not much discussion on that. That's my answer, I will be honest with that. Thank you.
And what do you think your government will treat the ESA as more like a piece of media regulation or communication regulation? So which authority will be nominated to become the digital services coordinator? What's your guess?
Well, the same like here. You know, they changed the name of the. There was a board of broadcasting and retransmission, and now it is media services board, something like that. So it's clear they have always played this important role, but we have a somehow tradition to follow what is prescribed, so to say, to be even more bureaucratic than, as we say, the Brussels is. So it will be followed that with some specifics. We go into details, unnecessary details, because there is low trust in society, basically. So we have to regulate everything. And the companies usually have this tradition, the TV companies and radio companies, good lawyers. You know, so there was always needed this kind of security guarantees on the part of the regulator. So there will be basically following the line of this Digital Services Act, but even more stricter, maybe. But I don't understand, because there are really so many complicated and competing, you know, regulatory aspects as I try to present, you know. So, for example, even now, as under this regulation which is there, you can ban or ask to be banned these websites or platforms for video for other reasons, you know, like this can be happen also, but not for this, for example, pornography, child, you know, abuse, all this kind of terrorism supporting. This can be banned on the other legislation I mentioned. So this is Cybersecurity Act deals content related to other aspects. So you can have all these aspects regulated and tackled from different perspectives.
Thank you. Now the third question related to Bernát's talk and aims at him. Could you expand on what aspects of navigation is in inverted commas, should be considered for regulation? If so, would this be exclusive public/private or co-regulation? Navigation, probably the question refers to navigation by the online platforms,
yeah, this
recommendation system.
Yeah.
That's my guess. It's not my question.
Yes, and I just mentioned it then because the first point is, I think, to turn the discussion more to the navigation problems than to the moderation problems. As I see, we are talking about more moderation, because it is always very interesting what to cancel, what to moderate, and how to moderate. But I think by now, to regulate the navigation systems with some new solutions is more important. And actually, I think what I'm saying is pretty close to Uta's claim, because regulating navigation is regulating some, if I want to put it in this way, some market failures, or the structure, at least the structure. So pretty close to I think to your claim, to regulate the structure rather than the content. So speaking substantially about what it can mean, it is really tricky, because the main problem is that we don't know now how these navigation systems work. We know almost nothing about these recommending systems. So in the DSA we can find these transparency obligations, which is very nice, and that should be really the first step to know how they operate this system now. And after we know more about these systems, we can come up with new solutions. I know it is not a strong answer, but I cannot see further now without this transparency. And co-regulation is really important in this sense, I think, because what the regulator can do is, and we can see it in other parts of the DSA, that to put principles in the regulation, but this will be always the providers themselves who put together the algorithms themselves. So it is not an easy question.
Okay, I don't want to release you from this question. Do you think that the traditional media regulatory toolbox can be helpful, well, not directly, but when thinking about possible solutions for the future? For example, must-carry obligation, the must-carry of certain amount of public interest content by social media providers, impartiality rules,
I think yes.
Right of reply rules, or public service media generally. The idea behind public service media can be somehow transformed into this context, at least theoretically.
Theoretically, my answer is yes, clearly. But I think now with this, we are at the point where we must also press the importance of a truly trustworthy source or sources that can be trusted by a critical mass of the society. If we don't have these sources, there will be no solution. So you can put the public service media and as a source in this regulation. If it is not trusted by the majority of people, it won't work. And so we can continue this slide.
Yeah, I was just thinking, as an additional response, what type of avenues might you take? And I know in Britain on the online safety bill, one of the things which I think has been in the sort of toolbox is to require platforms, for example, to allow users to verify and then basically allow users also to choose only to interact with other verified users. In other words, to require platforms to have a certain functionality that empower users that platforms may or may not have currently. I think there may be more specific things that can be done, which are simply requiring platforms to create a more sophisticated functionality that then may encourage users who would be discouraged currently from interacting.
Okay, Andrej?
See, this. Actually, I commented on Digital Services Act 6 months ago, actually, in my country, and discussion there was in one of the major newspapers, and basically it was very simple discussion, but not my fault. There was discussion argument was whether there should be regulation or not. There was one representative of neoliberal think tank who argued, they usually argue against any regulation, anything, So I said, well, I explained the reason why there should be necessary regulation of social media. This is one idea. And the second argument I would like to mention, we have written together with a Polish-Hungarian partner, author article on this Digital Services Act. And there were two major issues which we found, we identified. And one was that after careful reading of this Digital Services Act, it is very vague. There are so many possible interpretations. It depends on the government and national legislation. Yeah. And actually, I contacted even the Press Department, the European Parliament at the time, because even the wording of that first draft, which was official draft, was not correct. Grammatically, there were mistakes. I said, what is this really official version? And she wrote to me, well, it is, but there are mistakes, grammar mistakes. We will correct them throughout the summer, and then we will get final version. So even that was approved by the Parliament, because members of the European Parliament intervened in that draft, and the version and changed content. So this was, and the second argument, what was there was, especially by the Polish colleague who identified it, inconsistency of different approaches of courts, European Court, Court of Justice, etc., towards some aspects of which is in the Digital Services Act, how to approach in the past, the Commission, and now, there was some inconsistency, different case law, etc. So this was which we identified. So there was this kind of discussion, but as I said, there were other issues discussed. Thank you.
Okay. I want to raise one last question, and if you agree, then I'd like to have short answers from all of you. Because I was thinking about the subject that is related to all of your presentations. So I found the disinformation problem that was explicitly raised by Andrej, but also relevant to your speeches, Bernát and Uta. Everyone knows the problem, so there's no need to elaborate on that. There are many information available on the internet which is just simply not true, and sometimes these are not dangerous at all, and sometimes they can create imminent danger. Remember the COVID pandemic, for example, or in a case of a very tense situation in a wartime or other political turmoil. What do you think what is the role of the state in this regard? Can law step up effectively against disinformation or fake news, which was the previous term? What's the role of private entities in this regard? By private entities, I mainly mean social media platforms and other online content services. And what's the, I don't expect you to answer all of my sub-questions, but I just want to give you the opportunity to react to maybe a couple of those. What is the interaction between the state and these private actors? Think about the enforced self-regulation by the online platforms that was enforced upon them by the European Commission several years ago, and the code acts like it is a self-regulatory tool, but it is something that was really enforced by the European Union. And will the Digital Services Act help in this regard? Because I only found some basic principles related to the democratic public sphere in the regulation. So it seems that the EU, according to the opinion of the lawmakers in the EU, old-fashioned legal regulation is not a proper solution to this problem. That's how it looks like at the moment.
Okay. Well, I think there is one deep problem. This is actually, I found it when I did a study. There is a certain part of the population which likes this kind of disinformation, fake news, conspiracy theories. It actually very much correlates with the number of those who love to read or watch these alternative news, as we call them, gently. It's about, I don't know exactly the number, like 10 or 15% of the population. You won't change them, basically. Even if you discuss with them, there's no way, I actually, if you're interested, met on the train recently, 2 days ago, a daughter of former dissident. And she claimed to me that she is highly educated, she reads Lancet, BBC, whatever. And what she told me, that the world is ruled by 21 families, including Rockefeller, and all these absurdities. I tried to argue about COVID also. No, no way. So the second argument is related to another conference I online visited. There was a US expert who said that you cannot really change people's mind through traditional propaganda or enlightenment campaigns in the media, whatever. It doesn't work. All the research supports that. So what is needed basically is somehow to change slowly the quality of education and at least public service media, and hope that this number of those strange people will be lower. You don't get to the 0, but if you get from 15 to 5%, would be really success, I think. That's one solution, and I think that's sad news maybe for you if you expect something solution, but I don't see any other position here. That's why also I'm skeptical about banning all these alternative news portals. These people, they need this kind of junk news or whatever, you know, that's no way to discuss with them. So this lady, she told me, her mother told her, if you can't persuade somebody in 2 minutes, finish, talk to him. You know, I go, well, I said, this is a discussion, I understand discussion. You mean that if I don't agree with you in 10 minutes, I'm lost for you, you know. That's total absurdity. She claimed me how I am educated. She is very educated. She reads German, English, follow situation because her mother told her, you know. So that's the situation. So, and the other question, there are too many, but I give room to others rather. Thank you.
Okay. Bernát?
You asked for short answers. Before the state, I would press the learning job of the society, how to understand how to handle this new discourse online and disinformation, this new online environment where more disinformation can come to us. But it, to some extent, it is working. The other day, I heard high schoolers debating on social and political issues, and one of them said something, and the other guys answered, yes, it's a TikTok fact. It's a typical TikTok fact. So I think we are learning. We are studying. We are learning this new online phenomena of discourse. But speaking about the state, I think the first step is what you just raised with your question before, that the first for the state is not regulate content, but help the structure create trustworthy, truth-seeking sources, journalism, media. In this, the state can have a very serious job to do, to finance them, to support them. And after this, when we will have, or when we have these kind of sources trusted by the majority of the society, then the state can create regulation to urge the platforms to use these sources somehow. So I think I see the right steps in this way.
Thank you. Ute?
I agree. I suppose as an example, I was thinking of Australia introducing a tax on platforms which goes directly to news sources, sort of traditional journalism, and I think that's very important. I don't think the state can get involved directly with what is and is not fake news. Having grown up in East Germany, I grew up with two parallel realities where the official state news were nothing compared to the news we all knew was. So there were sort of two parallel worlds where the information didn't match. So I would be distrustful of the state making those decisions. But that's not to say that the state cannot get involved on the basis of supporting proper journalism and maybe also in a structural way regulating platforms whereby they must sort of deal with certain amplification mechanisms that push news that are sensational over news that are, you know, more trusted generally.
Thank you. So we received one last message through the Slido system, which says that great discussion. Thank you. So this is a proper closing for this part of the conference. Thank you very much.